what to know about inherited property taxes when managing California probate. That's our topic today. We'll get started right after this. In November of 2020, Proposition 19 passed here in California. The positive thing is it gives people over the age of 55 more flexibility when transferring their property tax base from a current home that they may have to the next home that they want to buy. This was definitely positive for California retirees because a lot of those people do want to downsize. Yet Proposition 19 caused some difficulties for those that are involved with an estate. It caused some significant implications for those that want to pass on their California tax base to their children or grandchildren, or from the children to the parents. So when involved with a California inherited property, like in the case of a probate in California, it changed things significantly. I'll be reviewing some of the Proposition 19's basic provisions as related to the California tax code and inherited property taxes here in California. I'll also go over a hypothetical case in which this new law is impacting the decisions that are made by those that are inheriting property here in California. Hi, I'm Kim Ward. I am a certified probate real estate advisor here in San Diego, California, and what I do is help executors, administrators, and sometimes trustees with a trust administration to understand the implications of everything involved when inheriting California property. Be sure to hit the notification bell and subscribe to this channel so you get all the information that I pass on. Of course, California estate and tax is really specific to each individual case. What I'm sharing should not be construed as a recommendation of any particular move. I always recommend that when involved with an estate situation that you do refer to an attorney or a tax advisor for those types of information. But this information will be helpful for you to understand the implications of Proposition 19. So let's get on with this hypothetical situation. This is a Proposition 19 inherited property. Let's say that your parents own the property for the last 35 years. And of course, their current tax basis, what they pay for their taxes every year, are relatively or substantially low to what others would pay for that same home in the current time. So if someone was to buy your parents' home, their property tax basis would get much larger. As in many cases with families, the parents in this particular situation have left the home to their children. They did that by either a will or a trust. And in that will or trust, they have put specifically how those assets should be split up amongst the siblings. Perhaps some of the beneficiaries would actually like to keep the family home. And maybe they're thinking, maybe I'd like to live there. Transferring a major asset, such as a home, can have substantial tax consequences. And now, because of Proposition 19, those taxes are much different than they were before that Prop 19 came into play. Up until February 15th of 2021, a personal residence transferred from a parent to a child or grandchild, or from a child to their parents upon their passing, was technically excluded from property tax reassessment. When I say technically, the parties needed to fill out particular documentation so that the San Diego County tax assessor knew that it was a transfer between parent and child. But now, because of Proposition 19, that is no longer possible except for certain cases. Proposition 19 now states that if the child is not using the home as their personal residence within 1 year of the date of the parent, that it is automatically reassessed for the property taxes. And I'm talking market value of what the property taxes would be. So let's look at how this may impact families and the choices they face in this hypothetical situation. And I'm going to even give a few more examples of when dealing with inherited property and a probate here in California. Generally, you're faced with two basic options. Allow the new law to go forward and take no action. For the purposes of this example, let's assume that your parents bought a home in 1985 for $200,000. And now, even though the home's current market value is $2,100,000, the property taxes are $4,000 a year. This would be based on the idea that when your parents purchased the house for $200,000, every year the taxes go up a bit. And so we're kind of basing this as an example where the taxes went up a little bit every year from 1985, and now they're at approximately $4,000. The reason taxes don't go up every year based on the value of the actual property is because of Proposition 13. That proposition only allows the property taxes to go up to 2% per year. So it depends on what the market's doing. If the market is stagnant and houses haven't increased in value, theoretically the property taxes wouldn't increase in value at all. This past year, we have had an increase in property values of over 20%. But again, the good thing about Proposition 13 is the taxes only can go up 2% maximum. So the other example would be, as the child of the decedent of your parents, you can move into their home and apply to have the property taxes remain the same as when your parents passed away. You would have to make this property your personal residence. Again, this should not be construed as any kind of specific advice. Please talk to your professionals that can really help you to make that kind of a decision, the choice of whether to move into the property to keep the property taxes the same, or sell the property, or let the taxes increase and rent the property. There's many options. No matter what choice you make, it's just, you'll figure out what is your best option to take. So here's an in-depth look at each option. Option number one is to sell the home in a timely manner. You and the other beneficiaries will inherit your parents' home. The income tax basis of the home will be stepped up. This is a tax advisor question, but it's generally going to be stepped up to what the market value was as of the date of death of your parent. What will also happen is from the date of death, the property taxes will be stepped up also in most cases. So it's something to think about, to consider moving along with the preparation and the marketing and the sale of the home so that that stepped up property tax basis is less. What I mean is that every month that the property is held by the estate, there will be additional property taxes that are ratcheting up, so to speak, and 6, 9, 12 months after the property is sold, a bill will come in due for those increased property taxes. So with the sell scenario, if your parents' home is worth $2,100,000 when you inherit it, even many years from now, if you decided to sell instead of right away, there would be that stepped up basis of $2,100,000 that the home is worth. And when you do determine to sell, you would only have capital gains on the difference between that $2,100,000 basis and whatever you sell the property for. So even though from the time your parents have purchased the property for $200,000 and there's a $1,900,000 gain, there would be no capital gains on that $1,900,000. The value gets stepped up. Again, please talk to your tax advisor to verify this information. So the rent scenario, let's talk about that. If the beneficiaries all decide to keep the property and rent it, the property taxes would be based on the current value determined by the San Diego County tax assessor. So the taxes from your parents' taxes of $4,000 would go way up to what the taxes would be for theoretically a $2 million property. So you can see why, if you want to keep the property, it would be a pretty prudent consideration to have someone move into it and make it their primary residence. I'm not exactly sure what the period of time is that they would have to live there. That would be something you should talk to your tax advisor about, but you could see how that would be a prudent move. Because here in San Diego, whenever I'm talking about property taxes, I consider the taxes to be 1.25 of whatever the purchase price is of the property. So you could see how your taxes on a $2,100,000 property would be over $20,000 a year versus the $4,000 that your parents were paying. So which option should your family choose? It depends on the many emotional and financial factors. If you have not yet sat down with your legal and financial advisors, now's probably a good time to do so. Thank you for watching. Again, I'm Kim Ward. Go ahead and like this video, subscribe, and hit the notification bell, and I'll see you next week.